So the Supreme Court rules that this JV cheerleader was removed from the cheerleading squad unconstitutionally. Here's why. Hey, welcome to the channel. My name is Nate the Lawyer. If it's your first time here, don't forget to like this video, share this video, and subscribe to the channel if you like what you hear. So this is a follow-up video to a previous video I did about the cheerleader who was fighting for her First Amendment rights. Now, this case was whether a public school can punish students for a speech that occurred off campus and over the weekends. Now, here's a quick summary of the facts. So this is Broady Levy. She was a 14-year-old freshman cheerleader at a public school in Pennsylvania. Now, Miss Levy went out for the varsity cheerleading squad and didn't make it. So after finding out the news, over the weekend, she sent out a post on Snapchat that said, quote,
"It was F school, F cheer, F softball, F everything."
The school got wind of the message, posted off campus on a weekend, and came down hard, suspending Broady from cheerleading for an entire year.
The school claimed that the post was disruptive to the school environment, even though the post was made over the weekend, not on school grounds, and not during any school activities. So the question is whether the school can punish a student's speech anytime, at home, or even on vacation. So we're all on the same page. The school lost at the trial court level and at the Court of Appeals. Now, both the lower courts ruled that schools could not regulate off-campus speech and that it was the parent's responsibility to discipline their children while they were at home and not government officials. But the Supreme Court, in an 8-1 ruling, agreed with the lower courts in the conclusion, but adjusted their reasoning. See, both the District Court and the Court of Appeals reasoned that schools could not regulate off-campus speech and that it was the sole responsibility of the parents. But the Supreme Court said that schools could regulate off-campus speech in limited circumstances. Now, to help understand why schools could regulate off-campus speech, the Supreme Court gives us a 3-part test. Now, the Supreme Court designed this 3-part test to help trial courts determine if off-campus student speech would be protected or not. So let's understand the test. Now, the first part of the test, a court is supposed to determine whether the speech occurred on or off campus. Now, if the speech occurred on campus, then the school's ability to deprive a student of their free speech rights are at its highest. For example, a government employee/teacher could tell a classroom full of students to be quiet, restricting their First Amendment rights. And if a student doesn't comply with that teacher/government official's directive, then that teacher could deprive that student of their freedom. It's literally called detention. But the Supreme Court makes it well known that the ability to regulate speech is limited even on campus. And for that, you can look up a case called Tinker v. Des Moines Independent School District. In that case, students wore armbands to protest the Vietnam War. And the Supreme Court said that the schools couldn't punish those students for wearing that armband because wearing armbands was not disruptive to the school's mission of educating students. But if we're talking about speech that occurs off campus, the court says it's generally the responsibility of the parents and not the school. Now, the court does mention that off-campus is now starting to become an open question. For instance, things like at-home learning. But a court determining whether this speech occurred on campus versus off-campus is going to be the critical piece of this test. Now, if the speech is off-campus, then the school's ability to regulate that speech is going to be severely limited. And then we look to the second part of this test. What type of speech are we talking about? Now, the court seemingly separates speech into 2 categories. Speech that likely could be regulated and speech that likely could not be regulated. So let's talk about speech that schools would likely be able to regulate first. The Supreme Court then goes on to reason for the second factor that if we're talking about speech that's related to a school program or activity, then schools are going to be able to likely regulate that speech. If the speech is bullying, harassing, threatening, cheating, or a substantial disruption to the learning environment, schools will also be able to regulate that off-campus speech too. As an example, if a student takes a take-home test, and the rules for that test is that students had to complete it alone. But if students are talking to each other outside of school about the take-home test, then schools would be able to regulate that speech. Now, on the other side of the coin, the court says that there are going to be types of off-campus speech that is going to be very difficult for schools to regulate. For instance, speech that's religious or political in nature, or any speech that's not related to a school program or activity. The Supreme Court says that public schools are going to have a heavy burden to justify any intervention in this type of off-campus speech. And then third, the court says the school has an interest in protecting students' unpopular expression, especially when it takes place off campus. See, the First Amendment protects unpopular speech. The Supreme Court then gives us this quote, "I disapprove of what you say, but I will defend to the death your right to say it." And simply put, uncomfortable speech is protected. So when the Supreme Court applied those factors to this case, this is how they came out. First, in regards to whether the speech was on campus or off campus, the Supreme Court says that this speech was made on a student's personal cell phone over the weekend to a friend's off campus, so this speech occurred off campus. As to the type of speech, the school says that this speech was related to a school program or activity, cheerleading. But then the Supreme Court goes on to note that this speech didn't target an individual. It didn't even name the school. This wasn't bullying, harassing, or even cheating. The Supreme Court then looked to see if this speech was a substantial disruption to the school environment. Here's a quote from the opinion. But when one of BL's coaches was asked directly if she had any reason to think that this particular incident would disrupt class or school activities, other than the fact that kids kept asking about it, she responded simply, no. So the Supreme Court said, well, this factor weighs heavily in favor of the cheerleader because this speech wasn't even disruptive to the school activity, even though it was about a school program or activity. Now, the last factor in the school's interest in protecting students' unpopular expression, they say this is a classic example of when schools are supposed to do that. Understanding, the court says, remember, protecting the right of free expression is a cornerstone of our way of life, and schools are supposed to honor that. This factor also leans in favor of the cheerleaders. So at the end of the day, the cheerleader's speech was 100% protected under this test. And the Supreme Court believed that this framework will allow schools and parents to understand the boundaries of the First Amendment. Now, at the end of the day, the Supreme Court is saying off-campus speech by students is given a higher level of protection than on-campus speech, but also understanding that schools have an ability to regulate off-campus speech in those limited situations that we talked about before, based on this test. So what do you think? Do you agree with the three-part test? Do you think the court got it right? Let me know in the comment section how you feel. And my name is Nate the Lawyer, and I'll see you next time.